Hello everybody, welcome to the fifth video in this series on Antonio Sledge and the state's misrepresentations with respect to Antonio. So this one is going to be a direct continuation of the first video, which discussed the fabricated, non-existent conviction for attempted aggravated sex battery that was referenced by the probation officer during the revocation hearing. It's this highlighted part here, reading out these prior convictions: 15 SC 138994, aggravated sex battery, attempted aggravated sex battery. Those don't exist. If you watch the first video, I explain it in more detail. But this video is going to discuss the state's doubling down on that statement, on that assertion, even after they've been told explicitly that it is a false claim. What we're looking at right now is the state's brief, their opposition to Antonio's appeal. It was filed September, just shy of 2 months ago. This is their statement of facts. Here we go. You can see that. The probation officer listed a theft by receiving stolen property case, give the case number, possession of cocaine case out of Fulton County. That's not his. That's the second video. Possession with intent to distribute cocaine from Fulton. Curious how they don't give a case number. And the attempted aggravated sexual battery. That was the underlying charge to count 30. Okay, so the first thing I want to show you is that they were told in our appellate brief that the condition did not exist. I'm sorry, the conviction did not exist, not condition. This is our summary. I wrote this part. Tiffany wrote the longer portion, but I said it right here. He has not been convicted of or even charged with attempted aggravated sexual battery. Tiffany discusses it in more length in the brief, but I mean, it really is a pretty simple concept. It's just not there. So this is in response to what we just looked at. So they had been told that it did not exist. They had the case number, told it didn't exist, and yet they double down and again claim that there is an attempted sexual battery. But that's not all. They also claim that the attempted sexual battery was the underlying charge to count 30. That's not a claim that's been made before. This is a new claim. A couple things. One, it doesn't exist, so it can't be the underlying offense to count 30. That whole existing thing is kind of an obstacle in these circumstances. Usually you want things that do exist, as a rule of thumb. It's nicer to have things that are real, but, beggars can't be choosers, I guess. So this is the original indictment. It's not really relevant, but you can see here the highlighted parts are the underlying offenses. There's no sexual battery. This is the re-indictment, which is the relevant document, and there is no, there's not even regular battery on this one. Case number, there's just no, it just doesn't exist. It didn't exist originally, and it still doesn't exist in a different way. So it doesn't exist in multiple ways. I don't know if that's like metaphysically possible. Like, can something not exist in different ways? Can you have multiple non-existing versions of the same thing? Because they have to have characteristics to be different things, but they don't exist. I'm sorry, they just broke my brain. There are different ways this non-existent conviction has been characterized. And this is after they were explicitly told that it doesn't exist, and yet they doubled down on it, told them here, and yeah. But in any event, that is another misrepresentation. I should have another video tomorrow if you're watching this on the day that I release it. Thanks for watching.